Hi, my name's Douglas Guilfoyle and I'm here to introduce International Law of the Sea at University College London. Let me start by telling you a story. In September 2013 there was an incident that you're probably aware of in which 30 Greenpeace protesters were arrested by Russia. And they were arrested after a couple of their number in inflatable boats had gone out to an oil platform and scaled it, at which point the Russian Coast Guard became involved. That incident resulted in proceedings in the International Tribunal for the Law of the Sea in Hamburg, in which the Netherlands argued that Russia had to release those protesters because in seizing their vessel, the MV Arctic Sunrise, there had been an unacceptable interference with freedom of navigation on the high seas. And why was the Netherlands involved? Because the Arctic Sunrise was flagged to the Netherlands. So a number of questions were immediately in play, and they're all questions of the law of the sea. What rights of law enforcement does a coastal state have over its oil platforms? How do those rights interact with freedom of navigation on the high seas? And this is one of the interesting things about law of the sea. It used to be regarded as a sort of technical, dull topic that had been settled when the 1982 Convention on the Law of the Sea was concluded, which runs to over 300 articles, several annexes, and 2 implementation agreements. And that was thought to be so comprehensive, there really weren't any questions left. And what we're discovering is there are plenty of questions left, and they're extremely interesting. Another major case for us, I suppose, at the moment is the situation in the South China Seas, where there are lots of disputes occurring over maritime boundaries. And a lot of those turn on questions of, as bizarre as this sounds, whether something is a rock or an island. Because a rock not capable of human habitation doesn't generate 200 nautical mile economic zones, only a 12 nautical mile territorial sea. And that could obviously make an enormous difference as to where you draw the line between, for example, China and the Philippines. So it's an incredibly interesting subject with a lot going on. And at UCL the course is taught by me, with occasional sessions taken by Dr. Ben Milligan from the UCL Centre for the Law and the Environment, and we occasionally try and bring in specialists from other organisations based in London that deal with law of the sea, though that varies from year to year. The course is normally taught as a small group seminar where a lot of discussion is expected, and we spend a lot of time looking directly at texts and maps in order to guide our discussion. So we expect a fairly high degree of participation from students, and normally it's quite a lively class. So what are the topics we cover? Well, we start with the history and development of the law of the sea, and it has some peculiarities to its logic. It's not entirely like other branches of public international law, but it touches on many of them, including environmental law, security issues, military issues, customary international law formation, the relationship between subsequent treaties, and so on. It's a very interesting case study for many public international law concepts. But in particular, the law of the sea is typically divided into functional and zonal approaches and the way those two interact. So we normally start with the zones. That is, maritime space is usually divided up by the distance from a coastal state, and therefore, what law applies depends on really what you're doing and where you're doing it. So if we sort of stand on the shore and look outwards, the first thing we're interested in is the regime of the territorial sea, the 12 nautical mile territorial sea, which is said to be subject to sovereign jurisdiction. We then have, beyond that, the contiguous zone, a kind of customs enforcement zone. And beyond that, a very important area in modern law and politics, the 200 nautical mile exclusive economic zone, which confers fishing and mineral and resource rights on the coastal state. But underlying the exclusive economic zone is an older legal concept, that of the continental shelf and rights in the continental shelf. So those are all areas subject to national jurisdiction, but then we get to the areas that aren't subject to national jurisdiction. The law of the high seas, governed largely by a principle of freedom, which causes a number of problems when we consider functional uses of the high seas, but also the deep seabed area with a capital A, which is referred to as the common heritage of all mankind, which has a highly specialised regime governing the exploitation of minerals on the deep seabed floor. Now that's interesting for a number of reasons, in that I say there's a detailed regime, but not every state is a party to it. Part of the United States' historic opposition to the Law of the Sea Convention is the regulation of deep sea mining, which is an issue we'll consider in some detail. So those are the zonal approaches to the law of the sea. We then come to the functional questions in the law of the sea. And broadly, we can think about these as including largely environmental and resource questions. But there are also other very important questions like the nature of marine scientific research and the different regimes it's subject to, both inside and outside national jurisdiction. So marine scientific research may sound not especially interesting on the surface, but it goes to questions like, well, what kind of activities can warships conduct in other states' waters? Is surveying the seafloor a military activity? It could be useful military intelligence. Is it marine scientific research, or is it simply part of the ordinary principles of navigation? You're doing this to ensure navigational safety. But the big issues, as I said, are environmental and questions of resource control. So we think of environmental law, we're thinking principally of the prevention of pollution and also fisheries management. Let me take the latter just as a quick example of how the law of the sea can sort of sound dull but rapidly becomes very interestingly complex. So I've talked about the zonal approach to the law of the sea, and of course a clear difficulty with that zonal approach is fish don't read maps. A fish stock might be found both on the high seas, in the exclusive economic zone, and in some cases like salmon, it might return to internal waters as part of its life cycle. So how do we manage that? How do we come up with a system that reconciles the need to manage resources and conserve them, but also a system that's based, as international law typically is, on states' consent? Well, we have general rules in the Law of the Sea Convention. We have more detailed rules in things like the Fish Stock Agreement that sets out general principles, but then we also have fundamentally regional approaches, regional fisheries management organisations. And then those organisations themselves may set up further regulations, some of which might have to be implemented in national law. So we potentially have several layers of international regulation, and not every state will be a party to each layer, which raises interesting issues of how these regimes interact. And while fisheries may sound at one level a little dull, it's critically important. Something like a third of the world is dependent for its protein intake on fish, and it's a major issue of resource security, particularly for African states. Having laid out all of those issues, though, we then usually turn to a couple of case studies in what I'd call maritime security. Increasingly, as the Arctic Sunrise incident that I began with shows, states are very concerned about what happens in their offshore zones. And certainly, when we think about fisheries management, that might be characterised as an issue of maritime security. But there are two other big topics as well. These include violence at sea, piracy and maritime terrorism. So Somali piracy has put the issue of piracy on the high seas back on the agenda in a big way. But there can be an interesting overlap here. Sea Shepherd, the direct action environmental protest group, was found to have committed acts of piracy by a court in the United States in taking potentially violent action against other ships in one case. So is that where we should be drawing those lines? The other maritime security issues tend to surround military activities, but also questions of smuggling drugs, people, or both potentially trafficked human beings and migrants. And we see increasing controversy over migrant pushback operations in the United States, Australia, and Europe and the Mediterranean. They're all states who have adopted a series of measures designed to prevent migrants moving by sea arriving on shore. But it's not just drugs and migrants that get smuggled. There's also been significant concern in recent years over the smuggling of weapons, particularly weapons of mass destruction or their precursors. So that's the broad remit of topics we'll cover in the International Law of the Sea course. And what we tend to do in our seminars is we start with those broader legal issues and the applicable law, and then narrow it down to some particular case studies. And so focusing on a couple of things in more detail and how the law applies to potentially important activities. One case study we've looked at in the past, for example, is the law governing submarine cables, which is largely a 19th century branch of law that underpins the 21st century economy. An anchor dragging incident somewhere in the Mediterranean cut off internet access for 75 or 90% of people in India in one event in the 2010s. So those are the sort of issues we discuss in our case study on, or case studies I should say, on maritime security. And there will be other case studies we look at as well, because that's our typical approach. We start with the broad law and then narrow it down to something concrete where we can tease out the issues in practice. That leaves us with one major topic left to discuss, which is dispute resolution under the law of the sea. And in brief, all I want to say about that now is that it's becoming far more important and far more lively. I started with the case before the Tribunal for the Law of the Sea regarding the Arctic sunrise, and we see an increasing number of law of the sea disputes, including surrounding the South China Seas and recently an arbitration between the United Kingdom and Mauritius over the marine protected area declared around the Chagos archipelago. And this now goes well beyond the sort of historic law of the sea dispute settlement cases, which were all about maritime boundaries. So that's the course in a nutshell. How do we assess it, you'll be asking? We assess it in a fairly straightforward way. There's a 3,000 word essay that is designed to allow you to explore one aspect of the course in detail, and then a 2-hour exam that is meant to test your knowledge of the course in general. And we have formative assessment that will help train you or give you feedback for both of those activities. So you'll be able to submit 1,500 words for comment towards your research essay, and you'll also be able to submit a practice exam question for feedback. So that's our approach to international law of the sea at UCL, and I very much hope to see you in class.